Good afternoon, everyone. We are just about at the 125 mark. Well, 5 seconds away, but I do want to get started just in the sake of time. So I want to welcome you all back. I hope it was a great lunch. And we're going to go ahead and get started with agenda item number 4. So, Madam Secretary, may you please call the next item?
Certainly. Our next item is item 4, private practice and taxpayer perspectives on intangibles assessment. Presentation and discussion from private practice and major taxpayer representatives on real-world intangible assessment issues and recommendations. Our speakers today, Brianne Rabowski, partner, Pillsbury, Winthrop, Shaw, Pittman, LLP. David Lenhoff, MAI, SRA, AIGRS Principal. Chris Daniel, SRA, Certified General Appraiser, Chris Daniel and Associates, LLC. James Pasquale, President and Chief Executive Officer, De Pasquale, Kelly and Company. Chris O'Neill, shareholder, Greenberg Traurig, LLP. Jason Chow, CFA, Managing Director, Stout, LLC. Mary O'Connor, Principal, Sikich, LLP.
Wonderful. Thank you so much, Madam Secretary. Mr. De Pasquale will be leading this group here. I understand you have maybe a few people online you want to recognize as well. You can go ahead and take it away when you're ready.
Thank you, Mr. Emron, and thank you, board members. And a special thanks to Malia Cohen's team for spearheading this and making this actually come to a reality for us, the executive staff here, for conducting a very professional process. Recognizing part of our team, our remote participants, David Lenhoff and Chris Daniel, here before you will be speaking first, and then we'll let David Lenhoff and Chris Daniel add anything to what we are presenting today. So we've heard a lot in the morning session. I am encouraged by the collaboration, first of all. And as chair and president of the California Alliance of Taxpayer Advocates, also a practitioner in my own group with a combined career in this industry of 36 years now, I was shocked to hear that this is a 100-year-old issue. So I can no longer say that I pioneered this matter, so I have to give up that title. I just want to make that known on record. So it's great that this is a constant conversation, although decades has passed since we've dealt with it before. But I will tell you this before I get into my submission, which I understand has been made part of the public record already, and each of you members have a copy before you. I will just read through it. The intent behind it is not to lay blame. This is an open discussion about what we can do to improve the transparency, the accountability, and the uniformity when it comes to valuation of taxable property. This happens to be an issue specific to intangibles today. But there are multiple other ancillary aspects that come into this conversation that are not just intangibles. So what I'm going to present is really going to be a broad stroke recommendation, identifying the problem, and a recommendation to the board that I think will at least set us on the right footing, regardless of where we end up as far as methodology and application on the back end. So that being said, as I mentioned, James D. Pasquale, I am the chair and president of California Alliance of Taxpayer Advocates, otherwise known as CATA. I'm also principal of De Pasquale, Kelly and Company. And for 31 years, we have been taking the charge on mitigating intangibles for our clients. That being said, it's been an uphill battle. I won't deny it, but we have made progress in open discussions with various assessors. And there is a recognition of the topic, but as was discussed earlier this morning, it's a complex issue. So we don't have easy answers, which oftentimes we end up in the appeals process and then ultimately in court, as we've seen the breadth of cases that have come forward. So let me just read so I don't get off track. So today, in addressing the important issue regarding the treatment of intangible in property assessment and why updates to the assessor handbook and related processes are necessary. At its core, this issue centers on inconsistency, lack of transparency, and gaps in current procedures when it comes to recognizing and valuing intangible assets in property transfers or annual assessments. The overview of the problem. Number one, lack of uniformity across counties. First, there is no consistent approach among counties in how intangibles are recognized or treated. Some assessors have informal or unspoken processes for handling intangible value, while others take the position that intangibles should not be recognized at all. However, this morning I will opine, I think we're past that point. However, within the same county, there can be conflicting interpretations. For example, an appraiser may attempt to quantify intangible assets collaboratively with taxpayers or its representatives, only for that work to be rejected at the supervisory level. In some cases, policies effectively force disputes forward, for instance, limiting reductions and requiring escalation to Assessment Appeals Board. Often, assessors will not grant reductions that exceed a certain percentage, forcing the issue to the AAB. If evaluation is supported by the data and evidence presented, there should be no threshold of value for resolving the matter on its evidence and merits. The result is a system where outcomes depend more on location and personnel rather than on consistent standards, which undermines fairness and predictability throughout the state. Number two, gaps in reporting forms and initial data collection. I was very pleased to see Deputy Assessor Daly bring up the point of information. This is very critical and probably at the forefront of the cog in this process. It begins on the front end of the acceptance process that was mentioned earlier. If information or data is not mentioned to the assessor on the front end, how would they know that they need to address intangibles or any other factors in the transaction or valuation that should be addressed? Key forms such as preliminary change in ownership reports, otherwise known as PCOR, change in ownership statements or COS, and 441D questionnaires. These forms have no place throughout that even ask the question whether they're intangibles. They ask every other question. They ask, what sort of debt do you have? They ask, what personal property do you have? But nowhere on the form does it ask the question, are there intangibles or some other aspect that we should consider? There's a one line that my firm, and I know other colleagues have adopted, squeezing in as much as we can to tell the assessor, hey, this transaction has special issues, we need to talk about it. But there's only one county in my career that's ever paid attention to that, picked up the phone and asked, what do you mean here? And that county has been very collaborative over my 3 decades of practice. In fact, they're the only county that's ever reached out. So it's important that we place more importance on these documents that are at the forefront of letting the assessors know what's happening with this transaction or this valuation. These statutory forms do not request any information about the intangible assets. Currently, they only include the prompt regarding the personal property value and no requirement to identify, allocate, or document intangible components of a transaction or annual valuation. This creates a systemic problem whereby assessors are expected to determine taxable value under Prop 13 without a complete picture of what was actually purchased or subsumed in the annual determination of assessment. In essence, assessors merely push the inflation button without regard for the nuance of inclusion of business value, goodwill, or other intangible elements. And again, this is not laying blame. There's just no mechanism by which to inform them ahead of time. So in my opinion, by updating those forms, we will at least create a mechanism by which it can be dealt with on the front end. As a result, intangibles are often overlooked at the outset, continuing in annual assessments and leading to inaccuracies that must be corrected through appeals or through the court system. Number 3, challenges of Assessment Appeals Board level. There's a knowledge gap of the Assessment Appeals Board level. Many administrative boards are not fully familiar with intangible asset concepts, accepted valuation methodologies, or legal and transactional structures behind these assets. Because of this, outcomes can vary significantly from case to case. For example, in some counties, in the same county, the outcome can vary whereby one AAB determines in favor of the taxpayer, another AAB in the same county denies it. I have personally been in front of AABs that categorically deny the existence of intangibles resulting in litigation that ultimately remands back to the board for proper treatment. In both instances, we prevailed, but not without great legal expense to the taxpayer. This inconsistency often forces taxpayers to costly and time-consuming litigation, and I would like to add a footnote after hearing this morning, similarly for the assessors and county resources. It stretches everybody. To resolve disputes that could have been addressed earlier in the process. We are at a point where the issue should not be a question of whether it exists, which I believe we've answered that answer. I think everybody agrees it's there. But more specifically, it should be about the value attributable to intangibles and non-taxable components. If reasonable data and evidence is presented, it should not be presumed the assessor is correct when they themselves have presented no evidence. Recommended solution. To address these issues, a structured and practical solution is proposed. First, the BOE should update standard forms like the P-Core, the COS, and the 441D to include a dedicated section for intangibles, value allocation details, and relevant transactional and cash flow information. Second, assessors should be required to consider all elements of transaction value, including both taxable and non-taxable components when determining assessed value. And third, taxpayers should provide documented evidence supporting any claimed intangible value allocation. So it's a two-way street. We can't expect the assessor just to believe that there's intangibles. The taxpayer and representative must provide them the proper evidence and documentation. Finally, once sufficient documentation is provided, the burden of proof should shift to the assessor consistent with case law, such as Weston St. Francis versus City and County of San Francisco. I'm going to leave that comment up to Mr. O'Neill, who's going to talk about the legal implications there. In summary, the current system lacks consistency, clarity, and completeness in how it treats intangible assets. By improving forms, data collection, standardizing practices across counties, ensuring informed decision-making, we can create a more fair, transparent, efficient assessment process for all concerned. So the end game here is that we have a transparent process that both sides, working at the benefit of the taxpayer, gets to the right result. Because that's why we're here. It's not for us, it's for the taxpayers. So with that, that ends my presentation. I'm happy to address any specific questions before we move on, or we can have everybody go forward and we can do the questions afterwards.
Yeah, if we can keep rolling and then.
Okay, I will turn it over to a colleague, Mr. O'Neill.
Thank you. Thank you, James. Good afternoon, Chair Lieber, and Mr. Imran, Member Vasquez, I say Member Gaines, but I don't think he's here, and Member Schaefer, who I'm assuming is with us. Thank you for this opportunity, and I think that when Controller Cohen put this together, it was very insightful in a number of ways. This is an area that does cry out for more guidance, and I think that's the key, guidance from the State Board of Equalization. I think it's timely. Even before Olympic and Georgia Partners was around, it was timely because there's a lot of history that's gone by. And I think this is exactly in the wheelhouse of the State Board of Equalization. This is providing help to assessors, taxpayers, assessment appeals boards on how do we do it uniformly statewide. How do we ensure that equalization is happening the same way, whether at the assessor level or at the AAB level, statewide? So it's perfectly in the State Board's wheelhouse. Let me give you a little background about myself. I'm a senior shareholder and attorney with the law firm of Greenberg Traurig, part of a 7-member state and local tax group in California with Greenberg. I've been practicing law for 42 years. 35 of those years have been exclusively property tax in California. both and I've mostly presented cases before assessment appeals boards, both in Northern California, Southern California, hundreds of cases, major cases, some of which have gone on to the courts. In fact, I've probably brought 100 court cases, Superior Court, Court of Appeal, and into the Supreme Court. There are a number of decisions, and I'm going to show you all the decisions on intangibles that have been issued by the courts of appeal, the appellate courts in California. About a third of those, I was either counsel for the taxpayer, or in the Elk Hills Power case, I represented as, I was counsel for the California Taxpayers Association as amicus curiae, a friend of the court. And in fact, that brief, a good portion of that brief was incorporated into the history section of the Supreme Court's decision in Elk Hills Power. I also currently represent the owner of the property in Olympic and Georgia Partners versus County of Los Angeles. I tried that case at the Assessment Appeals Board level, presented the intangibles evidence. The witness who presented that evidence is Ms. O'Connor, who sits next to me, and she's going to talk in a bit. So you have firsthand before you the people who are involved in the Olympic and Georgia Partners case. And I've been involved in quite recent decisions, SHR St. Francis in San Francisco that came out 2 years ago, SHC San Mateo, it's versus San Mateo, SHC Half Moon Bay versus San Mateo, DFS Group versus County of San Mateo. Those are all cases which I handled on behalf of the taxpayer all the way through either the Court of Appeal or the Supreme Court. When SB 657 was passed in 1995, I was part of the team of attorneys who were working alongside Caltax to get that passed. When AH 502 was amended in 1998, I worked with Doug Moe. Doug Moe and I think one other attorney, were the primary authors of the industry version of that portion of Chapter 6, pages 150 to 165. A good part of that I wrote along with Doug Moe. I know what's in there, and I'm going to have some comments about why I think it's still a good guidance document. I've written a seminal article on intangibles that's been published by the California tax lawyer. I am the co-editor of the leading treatise on California property tax law called Taxing California Property. Chapter 4 of that is mostly about intangibles. I wrote that chapter. And I've mentioned I'm involved in the Olympic and Georgia Partners case, which is on remand from the Supreme Court and currently waiting for a remand hearing before the Los Angeles County Assessment Appeals Board. And I think to answer your question, Mr. Vasquez, a decision on what is the value of those three intangibles that were at the board before and have gone up to the Supreme Court and back down again still hasn't been reached. That we need to have a hearing to determine what is the value of the management agreement, what is the value of the assembled workforce, and what is the value of the food and beverage operation. That still has to be done because it was not decided by the Assessment Appeals Board the first time around. So let's talk a bit about property tax. Some of this is going to, you'll see, follow a bit of what Mr. Moon had to say. Property tax is constitution-based. That makes it different than a lot of other taxes. What property gets taxed? The value standard, the requirement for equalization statewide, all of the right to, or the possibility of getting exemptions. The origin, the basis for this organization existing comes in out of the Constitution, and even assessment appeals boards are found only in the Constitution. The legislature had no creation of any of these things, nor did the governor, nor did the executive branch. This is a constitutional area of law, of property, of tax law. Because of that, who interprets the Constitution? The courts. Because of that, most of our law in the property tax field in California comes out of the courts. That means we have to be able to read opinions, understand them, follow them. And I'm glad to see that's part of what we're doing here, because that needs to be done. I have the same concern that Mr. DePasquale has, and that is that I meet a lot of people who say, oh, I've read Olympic and Georgia Partners, and I think it says this. And then I'll say, have you been to law school? Do you have a bar? Did you pass the bar? How many cases have you read and studied? And generally, you have to read those cases over and over again in hours and hours and hours. On the way, I was on an airplane coming back from overseas 3 days ago. I read Rome versus County of Orange. It took me 2 hours to read a 10-page case to understand it fully. I say this because most of the assessment appeals boards that I go in front of, with maybe the exception of Los Angeles and a few other metropolitan counties, are not staffed by attorneys. They are staffed by appraisers, realtors, accountants, and they do not know how to read a case. So they have, many times you'll walk in and at the end of the case, someone will throw 3 cases on the desk of the board and say, read those, that supports my decision. This will support what I've said and it'll be the basis for your decision. Those board members have no ability to read those cases and fully understand what they mean. The same thing, and I don't mean to pick on assessors, but most assessors are not lawyers. I have known a few who were, but most are not. And recently I tried a case in one of the Southern California counties in front of an assessment appeals board. And I had an assessor say to me, the issue was, an assembled workforce, which is an intangible. And we said, we think there's an assembled workforce here. And that particular appraiser who was working on the case that day said, well, California doesn't recognize assembled workforce as an intangible. And my mouth dropped open because there's 6 published Court of Appeal decisions that recognize assembled workforce, plus the assessor's handbook. And then you get and we have to look at everything on a case-by-case basis because that's what Olympic and Georgia Partners says. We can't have this kind of misdirection occurring in assessment appeals boards. And I realize assessors' offices have attorneys. Those attorneys are very busy. Los Angeles has 2 attorneys assigned to help the boards. And I think 1 or 2 to assign to us help the assessor's office. That's not enough lawyers. So what do? Well, we have to have guidance from this body on how we interpret these cases and then establish the principle. And once the principle is set, and Mr. Moon did a nice job and Mr. Young did a nice job of setting forth some of those, that goes into a document, a guidance document that this board issues, and it's done. And we don't need to deal with it anymore. We don't need to have wild interpretations of what a case says or what a case means. Before I go on, I want to say something else. And having been an author of AH 502 section on intangibles and having used it regularly in front of assessment appeals boards, the assessment appeals boards very much glom onto those 16 pages in Assessor's Handbook 502 and look at them and usually often decide cases based on those. Let's not change the guidance in 502. It is still good guidance. Probably not me, but Mr. Moe, Doug Moe, when he helped write it, he must have been thinking 15 years ahead because a lot of what is said in there has since been followed by our courts. And I think it would be a mistake for the board to say we're going to gut that portion of the handbook and rewrite it. In my opinion, besides the courts have relied upon it, it's been quoted by several court decisions. Assessment appeals boards are relying on it regularly. And I think instead of going down that road, I would say let's supplement. I would ask the board, consider seriously supplementing what's in Assessor's Handbook 502. Affirm what's there and then supplement it. Now, sitting before you is a document that I prepared and submitted. You submitted it yesterday, but been working on this document for about 4 months. This is a proposed letter to assessors. And it is in the form of a guidance document. You may know, but if you go on the State Board's website, the State Board has published about 20 guidance documents. They're on their website. How to assess billboards, how to assess cable television and video service, how to assess solar energy, how to assess wind energy. The one I think that's very pertinent here is how to substantiate additional obsolescence for personal property and fixtures. If you go and you look at that particular guidance document, it is all about appraisal, and it's very detailed, and it tells people how do you determine basically obsolescence and depreciation when you're evaluating personal property. I'll get to it in a little while, but I think that's where the board needs to focus, and I think that should be the direction that this project or this work group heads in down the road. But first, I just want to walk you through, very briefly, this proposed LTA. It contains a brief history of the valuation of intangible assets and rights. I'm pleased to say it almost mimics what Mr. Moon and Mr. Young presented this morning, so I think we're very consistent on that. I've taken a little extra time and footnoted some things just to tie it back to the case law, but I think a lot of things are established, like Rome says we're going to exclude or exempt all intangibles, for example. I'll get to a few, we're going to exclude all intangibles. Other principles that I'm going to get to are also in the history. And that's why I think we need to chronicle this history going back to 1998 and cases coming forward. It next talks about the identification of non-taxable intangible assets and rights. We're not in the never land. We're not lost there. There are actually treatises issued or published by appraisers who specialize in valuing intangible assets and rights. And there are detailed lists of the requirements that have to be met for you to have an intangible. Ms. O'Connor actually uses those when she's valuing intangibles for her property tax cases here in California. Then I put in a section about valuing specifically identified non-taxable intangibles. And I put that there because there are some general principles that the courts have given us that we can use, that the board can use as a starting point in drafting the guidance I think that's needed in the area of valuation, which is our topic really for today. That carries over for several pages. I do have a section about burden of proof, and I commend that to your review. The courts have told us actually that the burden of proof in intangibles is on the assessors, not on the taxpayers. There's 3 cases that tell us that now. And finally, and this is where I think the really important information can come from, approaches for valuing specific types of intangible assets. You've heard about hotels today. Almost every hotel has a management agreement, a franchise agreement like a Marriott or a Hilton, a workforce in place, especially if it's a large hotel, and probably a large food and beverage operation. Those are the primary 4 intangibles in every large luxury hotel, resort hotel. We don't have to go off into, was there a TOT agreement for development of that property? That's a one-off. Olympic and Georgia Partners, there probably will never be another case come forward that talks about using TOT to pay a developer to build a convention center hotel in downtown Los Angeles. Matter of fact, when we put that case on, we went out and looked, are there other TOT agreements out there? There are a couple, maybe. So, but these 4 always exist. Well, what if the board said, we're going to put out guidance on how you value a management agreement? Every hotel's got one. Let's just tell people how to do it. Or a franchise agreement, or a workforce, or even a food and beverage operation in a large hotel. Finally, I've concluded this with what I think is important. Like the handbook for possessory interests, which has a summary of all the possessory cases, I put at the back of this a summary of all the cases in the intangibles area. There's 25 of them. I put a short, 3 to 4 sentence summary of each one. I think that's helpful, be helpful to the board just to be able to look through that. And finally, I conclude with a short bibliography also, which is a resource. So that having been said, let me talk about, we've talked about what questions are remaining out there. Well, I don't think there are really any questions except how do you value a Hilton franchise in a hotel? How do we determine the value of a workforce that's operating a petroleum refinery? The questions, the issues I think that are already resolved are these. All intangibles are exempt from taxation with limited exceptions. And those exceptions I put to you are found in Revenue and Taxation Code, Section 110F, which are the intangible attributes of real property: location, zoning, architecture. Number two, the value of intangibles is the full value, and it's the full value of every intangible that must be removed when valuing property. There's a lot of discussion that it centers around this beneficial or productive use. I'm going to talk about that in a minute. And people will say, well, we've got a real property that's using an intangible, and those intangibles are causing the property to be put to its beneficial and productive use. So we have to take that intangible and we have to split it somewhere. 40% on the real property and 60% is the intangible. That's not the guidance of the courts. If you read Elk Hills Power in particular, if you read the statute, if you read GTE Sprint, the standard is identify that intangible, determine its full value, and subtract that full value out. We don't split the intangible. California made a decision, the courts made a decision 20 years ago that we don't do that anymore. And that was a big issue. In 1995, that was a question, that was a big issue. GTE Sprint in 1994 solved that problem, and Elk Hills Power confirmed it in 2014 when the Supreme Court issued that decision. Here's an important one. This assuming the presence, we hear about it, we read it in the statute. So it was the center of the case in the Supreme Court's decision in Elk Hills Power. You know what the Supreme Court told us in Elk Hills Power? Everyone overlooks this, it's in a footnote. Beneficial or productive use just means we value the real property in its highest and best use, okay? So we're gonna value that hotel as if it's got a Marriott franchise, it's got a workforce in place, and it's got a big food and beverage operation, as opposed to not having any of those. That's how it gets valued. Highest and best use is a common thing. It's the first step in any appraisal assignment. What's that property's highest and best use? Highest and best use is not a value element. So what it's saying is when you value a real property, just make sure you're valuing it as a hotel and not an empty apartment house, for example, or not a refinery that's not in operation because it's dark, because it's been closed down and there's no workforce there. That means, of course, that then we remove the entire intangible. We don't remove a part of it, right? The overarching, I think I've given this already to you, the overarching methodology for valuing intangibles is set forth in GTE Sprint, and it is identify, value, and deduct. It literally, that's what the case says. Identify, value, and deduct. Well, we've already taken care of identification. It's not hard to identify intangibles. Now, granted, okay, an agreement using transient occupancy tax to rebate to a developer through a complicated financing scheme, which is what we had in Olympic and Georgia Partners, that one is an uncommon, a unique, off on one side. But otherwise, they're pretty easy to identify, and I'm gonna talk to Ms. O'Connor about that in a minute. Deduct, everyone can agree, okay, well, we're gonna subtract. Whatever that intangible is, we're gonna subtract its value out. What are we left with? We're left with value. We have to value that intangible. Once we all know how to value it, whether it's a small county like Glenn County or the big behemoth, Los Angeles County, once we're all on the same page on how to value it, it's done. And if those intangibles are common ones, like every hotel has a management agreement or a franchise or a workforce, and the board has told us how that's done and maybe provided training to assessors on how to do that from credible resources, that solves the problem, and that's the guidance that I think we need. Well, let me see. I'm going to skip some of these other ones. Other issues have been clearly, we know, for example, an income approach always captures intangibles if you use the entire income coming off the property. And why is that? Because if the income coming off the property has a stream that's going to return to real property and a return to the building, and then a return to the Hilton franchise, and a return to the workforce in place, and a return to Wolfgang Puck, who's operating the hotel's food and beverage operation, well, 3 of those are the intangibles. Those income streams should not be included if we're going to value the hotel. So we value those separately. What's the value of Wolfgang Puck's name on a restaurant? What's the value of the workforce that's there in place? What's the value of that Marriott franchise? We pull those, actually this was Olympic and Georgia Partners. Those were the 3 intangibles. You pull those off and you're left with real property, taxable real property, land and improvements. I'm not going to talk about the Rushmore method. I think there's still a dispute there. What I would like to do is I'd like to introduce Mary O'Connor, who's sitting next to me, and I'm just going to briefly talk about Ms. O'Connor. Ms. O'Connor's been, you've been practicing, I guess, more than 45 years in the...
You don't have to put too fine a
Okay,
point on
I'm
it.
a long time. And the thing about Mary O'Connor is she's not an MAI appraiser. She doesn't value real property. She's what we call an ASA appraiser. She's certified by the American Society of Appraisers, a very large appraisal certification organization, and they train appraisers to value business intangibles. And she actually has a specialization in that. And I want to ask you a few questions. I guess, is there a segment of the profession then that actually focuses on intangibles appraisal?
Before you go on, Mary, Chris, I appreciate that presentation. I want to do a time check here. We're allotted 90 minutes
Yeah.
for the presentation. We're just about 35, 40 minutes.
What is my time right now?
The group's time is 90 minutes total.
What are we at?
We're about 35, 40 minutes, yeah.
Okay.
So-
As soon as I introduce...
I know we have about 5 more speakers to go, so however you guys want to
Okay.
keep the pace
Got it.
going, but I'm going to have to
Reading
stop
my
it.
mind just now. so
Okay.
He tends to go
Okay.
on.
However you guys
Mr.
want to
Connor, I-
continue to go, okay?
Give us an overview of intangibles appraisal profession and what intangibles appraisers do and how that's been brought into the California property tax world or arena.
The valuation of intangible assets really got started in 1934 with the publication of several learned treatises, the entrance of the Internal Revenue Service into regulating that particular space. Utility rate making picked up the appraisal of intangibles, the litigation of intellectual property across the country, financial statement reporting, it uses the appraisal of intangibles extensively. In financing, we always want to identify and exclude intangibles. Certainly in federal income tax, it's extremely important. Since around 1934, generally speaking, out of academic universities in the economics departments and in the finance field, appraisers who specialize in the valuing of businesses and intangible assets, for the most part, we subscribe to standards 9 and 10 of USPAP, which they mention intangible asset appraisal quite often, and those are the standards that I'm regulated under. There are literally thousands of people like me with my credentials serving in various aspects of the business community, particularly in mergers and acquisitions. I suppose I'm a bit unique in that I took that background and applied it to California in property taxation. Property tax is a unique purpose. You need to always appraise per the unit that we're appraising, not as if it's part of a larger corporation. It also, I think, it needs to be simple. It needs to be easy to explain. It needs to be, it can be templated in ways that could be universally used throughout the assessment community and the taxpayer community. I think people get right up to the subject and get a bit scared of it, like this is going to be horribly complex. The principles of appraisal never change. It's the income, the market, and the cost approach. Doesn't change. How it's applied per purpose changes. Certainly in California, we have a rubric. You identify the intangible, you value it, and you exclude it. It is not necessarily done that way in other states. So for 25 years, I have been providing this service. I have been the expert in most of the cases that we have brought up today. The template that I use is simple, and it is not particularly complex. I think if generally applied, 85% of cases could reasonably, you could come to a meeting of the minds between taxpayer and assessor relatively easily. What is occurring throughout, particularly in California, is that my template, a few other appraisers' templates, they're now kind of in general circulation, and people who don't understand the appraisal theory behind it, who aren't certified in it, who don't understand the information sources that are required, there's a lot of winging it out there. And that's not serving the community either. I think the BOE could do a tremendous service in being able to move these cases along to where we're not talking about 15, 20-year-old cases. We're moving them along where taxpayer and assessor can discuss assumptions within a template, come to a meeting of the minds, and move on. Something that's also easily trainable. It's just something that property tax in California needs. Now, also congratulate yourselves. You do realize that in the other 49 states, they all talk about your cases, your templates, your reports, and they use that as a standard. That's where the Disney cases in Florida have come out of. They extensively discussed your state's leadership in this area. And you're also the first group of people that say, well, we need to bring this up to date. And within the assessment community, your work will be looked at by 49 other states. This is not an unknown issue. This is not a new form of appraisal. This is USPAP 3 approach appraisal that has thousands of certified practitioners that can assist in this process. It needs to be tailored to property tax, but that is a relatively, I'm not going to say easy, it's easy to understand once it's articulated.
Thank you. Thank you, Mary. We're going to move on to Brianne Robowski. She has some comments to make and maybe something special to add.
Perfect.
If you could put the
Good
mic
afternoon.
a little closer, Brianne.
Sure, yeah. I usually talk really loud, so I'm not used to having to be mic'd. So good afternoon, everybody. I'm Brianne Robowski. I am a state and local tax partner at Pillsbury Winthrop Shaw Pittman, so I'm an attorney. I have specialized in complex California property tax for the last 15 years or so, pretty much exclusively. I've handled a number of different intangible cases during that time, both at the Assessment Appeals Board level and at the court level, some including currently and some cases that are being watched very carefully. So thank you very much for having me, and thank you for spending the afternoon with us focused on this. So I like to fancy myself sort of a problem solver. I like to be somebody who comes to the table with a suggestion and looking at both sides of this. And what I really hear coming out of this afternoon is a deep-seated desire by both sides for guidelines and, to the extent practicable, bright line rules. And it's really interesting because if you take a step back and you look at the body of law that makes up the 25 cases that Chris talked about, they can be quite confusing at first blush. They feel like they're all over the place, and you kind of can't make sense of them immediately. And you might find yourself wondering, well, how can there be cases in which an intangible is identified, and there's even a value for that intangible, but yet the court finds that no deduction is needed? And so this has sort of permeated and created this real set of confusion throughout the assessment community and the taxpayers community. And it's where you see most of the issues sort of butting heads. But I have really good news because I think that there is a bright line rule. And I think that that bright line rule really was heavily punctuated out of Olympic Georgia and Partners by the California Supreme Court. So what I'd like to do today, and I'm going to try and keep my comments pretty pointed and pretty short, is I'd like to explain this bright line rule to you. I'd like to explain how the case law aligns with it. I'd like to briefly tell you why this is the rule, and then how it fits within the parameters of Olympic Georgia and Partners, and help demonstrate the rationale that sits behind it. So let's first start with what is this mysterious rule that I've been referring to? Well, it's really the division within the case law between a government-created intangible and a privately created intangible. And there are lots of examples within California case law that really demonstrates that really bright dichotomy. So if you start on the government side, and on the government side here, we see if it's a government-created intangible, the cases say no deduction is generally required. There are some nuances to that, but generally no deduction is required. If it's a privately created intangible, there we do see a deduction routinely required by the courts. So government-created intangibles in the case law are things like the land use permit out of American Sheds. It's the FCC license out of Los Angeles SMSA. It's the standard offer contracts that are talked about in the Freeport and Watson cases, all of which I trust are in Mr. O'Neill's draft LTA. Those cases demonstrate government intangibles. Those cases don't require ultimately a deduction. Let's move to the other side and start to understand the other side of a coin. Here we have privately created intangibles, and here we have a very robust set of case law that helps demonstrate this. In fact, both parties have talked extensively about multiple examples. We've talked about goodwill since early this morning, numerous cases identifying goodwill, and the classic effort that goes into private companies building out goodwill out in the community and building that value. We've talked extensively about workforce in place. We've talked extensively about many other things, including favorable operating contracts, which come in many different flavors and sorts. And the list really goes on and on. But therein lies sort of the dichotomy, the government-created intangible versus a privately created intangible. So I indicated that I was going to help you understand why. Why is there this dichotomy? Why does this make sense? Well, let's start on the private side. A privately created intangible is really something that needs to be deducted because it's reflective of enterprise activity. You see all of the cases talking about whether or not an intangible is largely derived from enterprise activity. Private parties seek out, engage in enterprise activity, that value must be deducted. There really is only the government-created intangibles that aren't created generally by enterprise value. Instead, it's a government allowance effectively. So we see things like licenses and permits. We see cases coming up with no need to deduct there because it's a government-created intangible. These are, to use the language of the court cases, intangibles that merely allow taxable property to generate income when put to its beneficial and productive use. So you can start to see how once you understand this two sides of the coin dichotomy, as I've been saying, why it all sort of brings the case law together. So let's take a look at Olympic Georgia and Partners, our most recent California Supreme Court case on intangibles. And that case actually, it's a long case. It's 80 pages as a slip opinion. And as Chris said, it's a case that takes hours to get through. And I've probably read that case 15 times at this point. It takes a lot of effort to get through. But once you sort of understand and appreciate the court's rationale, it actually makes quite a lot of sense. So Olympic Georgia and Partners really demonstrates this bright line test that I'm talking about here. And what Olympic is focused on is the narrow carve out of a government-created intangible for which no deduction is required. And in those instances, when no deduction is required, you can, it's a very narrow exception, use actual income, also known as contract income. So what is this thin reed? What is this narrow exception that I keep referring to? Well, I've been calling it the Duluth government exception because the creation of a government-created intangible and the need for no deduction for it was created by the California Supreme Court. And that was all the way back in 1955. So let's take a really quick look at that particular case and what the California Supreme Court was looking at when they carved out this narrow government-created intangible exception. Well, it really dealt with military housing. It was a new housing development that had been developed under the National Housing Act. And we saw the military come in and say to the developer, here is your dictated rent, and I'm going to guarantee your occupancy with people that I tell you you have to rent to. Well, what does that do? That creates an above-market rental income stream that is government-created and government-backed. Who did that? Did a private party do that? No, the government did that. So what did the California Supreme Court say about that? Well, they said, okay, in that instance, that's different than private enterprise activity. This is government created. There you get to tax actual income. You get to tax the contract income with no deduction for your intangible. So flash forward to when is the next time this Duluth government exception is used? It's in 1993 in a case that's well known and well discussed and causes quite a lot of consternation among the broader community. It's Freeport-McMoran versus County of Lake. This particular case dealt with what's known as a standard offer contract. That is a contract that is created by the CPUC, a government entity. It's drafted by the government and it's held out to developers. Any developer that wants to develop a renewable energy development grabs that contract, picks it up, signs it, and all of a sudden they're a renewable developer. That is a government created and government guaranteed because it indicates pricing after you've developed your renewable that they're gonna pay you for your energy pricing that you're selling out to the utilities. Government created, government backed, dictated pricing by the government. Again, we see the courts relying specifically on Duluth. They cite back to the California Supreme Court's case and they say, aha, this is a government created intangible, therefore no deduction is required for this particular intangible. And helpfully, the court actually takes it a step further and it says, well, why is this different than an above market lease? We haven't really gotten into it much yet, but that's the classic example that everybody talks about. And in fact, Property Tax Rule 8D specifically says an above market lease is not subject to tax. We look at market rental rates to reflect a hypothetical willing buyer, willing seller to determine fair market value. Well, the case in Freeport said it's different than an above market lease because it's government created. An above market lease is the product of private negotiations. The next case that you see is Watson-Cogen versus County of LA in 2002. And we can shortcut that for purposes of today's presentation to effectively say it relies squarely on Freeport, the case we just discussed, and squarely on the Duluth government exception that I've articulated. Next, where do we land? The next case that brings us up is Olympic Georgia and Partners 2025 case. And what is Olympic Georgia and Partners looking at? They're looking at a TOT occupancy agreement, an agreement that was created by the government, by the city, who dictated what they were going to give back to a developer to incentivize development. Again, we have the same hallmarks. We have government created, we have government backed. What does that mean? Government created and intangible under the Duluth Homes government exception doesn't require a deduction. And you see again, it looks back at the same distinction between an above market lease. It relies on Freeport to do that. So I take a step back from this and I look at all of the confusion that Olympic has created. It's quite disappointing as an attorney to see a case go up to the California Supreme Court after well over a decade of not an intangibles case, and all you get is 80 pages of what feels like a mess. But now, having put all the pieces together, I see how it makes sense. And we see the Supreme Court saying, this is a narrow case. This is a case that's specific to these facts, these unique circumstances, as Mr. O'Neill was explaining to us. Why? Because the government-created exception is narrow. It is just living in this narrow set of cases that we've talked about here today. So I offer that as sort of a bright light of hope, hopefully, that there are bright line rules out there. There is a lot of confusion, but as Chris said, you really have to look at the full body of law together to make the cases make sense. That's our duty as attorney, to harmonize the cases. And it's sort of like once you've seen this dichotomy, it all sort of makes sense and you can't kind of unsee it, so to speak. So I just wanted to sort of provide that as an example to the board of something that I think could be quite effective. It's bright line, it's easy to administer, it's very well supported in the case law, and it really brings everything together and updates what is currently stated in Age 502. Happy to answer questions. I did go longer than expected, but I appreciate your time.
Thanks, Brianne. We have Jason Stout next. He's going to kind of wrap up on a more tangible personal property, or, okay, so I'll let you take it from there.
Great, thank you. Chair Lieber, members of the board, thank you again for the opportunity. Glad to be working on, as part of this working group here. And I would just say, where I'm going to focus is going to be an aspect of intangibles that is going to gain some more visibility. I think we've talked a lot today as to the non-taxability of intangibles and as it relates to real property and businesses. And what I want to do is introduce to you some insights and perspectives as to how this might play into business personal property. I'm not an attorney. I'm also a practitioner like Ms. O'Connor, and I've been doing this for about 30 years, valuing assets for property tax purposes. But I would say many of these years now have been focused on intangibles. And what I've seen is the importance of intangibles not only spans the business enterprise, real estate, but also business personal property. And what's happening, and what I want to do is just give you some trends, give you some examples, and then a little bit of the practical application as to what's going on in this area. I would say over the past 30 years, as it relates to intangibles, everything has increased in its contribution and its value. And I think especially today, when it comes to businesses and they're making investment decisions, they are paying this premium, and the premium is being driven by the intangible component. And all the assets today, whether it's a business, real property, obviously, but even business personal property, have a component of both tangible and intangible. I would say when it comes to the issues that have been discussed today as it relates to real property, whether it's uniformity, whether it's transparency, and even the cases that have come up to test the intangible component, that's also going to be an area then that they may come up on business personal property. I think it was briefly mentioned today by Ms. Ruart as it relates to data centers and embedded software. Well, guess what? What we see in business personal property is a growing proportion of this intangible. It's intellectual property. It's not tangible, but it's important when it comes to business personal property. And the reason why companies are investing in these types of assets is because it's mission critical. What it does is it allows companies to better compete in their respective markets. It better serves customers and stakeholders. It protects against cyber attacks. It allows companies to access data to make better decisions. It provides automation, and there's a whole host of benefits when it comes to purchasing assets that allow companies to become more efficient. So I think when it comes to the practical application of business personal property, where you see this with companies beyond just what's in the real estate is in the telecommunications industry, in the electric and utilities industry. The form of application software is widespread. And I think even given today, you see so many other industries investing in these types of assets, whether it's transportation, medical, manufacturing, distribution. And I think what's happening here is that companies have to pay a premium price for these types of assets. It's a price then that is going to be growing and continuing to be a larger proportion of what they pay in property tax. So I think today it's really just to bring to your attention that I think this is another area that's worth exploring because the intangible is also going to be an issue then that will require some guidance, whether it's the identification, but also the measurement. And I think it's learning from everything that's happened in real property and being able to utilize that when it comes to business personal property. So I just thought to spend a couple minutes just to introduce this concept. So
Thank you very much.
Appreciate that.
Mr. Emron, I'm going to yield to you to see where we're at right now.
We're just at the hour mark. You have overall 30 minutes left in your presentation, maybe 20 with a little bit of Q&A. So for staff, we need to take a break.
Okay.
10 minutes, just everyone collect themselves. If we can come back at 2:36.
I just want to see if the two members on the remote access, Mr. Daniel and Mr. Lenhoff, if they need, how much time if they intend to speak.
This is Chris Daniel. I'm going to need at least 15 or 20 minutes. Yeah.
Well, we'll give you 10 if you can condense it.
Well, I
Because
will do what I
we
can.
need Mr. Lenhoff to chime in as well if he's going to. Otherwise, he can
Yeah.
yield his time to you. Mr. Lenhoff?
Well, no, I don't want to take away from Mr. Lenoff. But we are, the ultimate goal here is to determine the value of the real estate, right? I mean, that's ultimately what we're trying to do here. So I had a couple suggestions that might help us along that way.
Awesome. And remember, this is just the intro to the working group, so we'll have other opportunities to
Yeah.
get more knee-deep.
Yeah.
Just want to keep it fair because we gave the assessors 90 minutes. You all get 90. But let's just take this 10-minute break. You guys maybe
Okay.
can huddle up, decide
Awesome.
how to move forward, and we'll come back in 10 minutes. Okay, so let's do 2:36. Thank you. We are in recess.
Awesome. Thank you.
Okay, everyone, we're gonna go ahead and get back started. We are in the home stretch here. Want to thank everyone. We have a few more presentations left. We're gonna move on forward here, and I turn it over to you, Mr. De Pasquale.
Thank you,
Pasquale.
Mr. Imran. Thank you. Mr. Daniels, did you want to kind of go forward and just keep in mind, just
Yeah.
try to keep it condensed
I've
without
got,
shorting yourself? Thank you.
No, I'm going to set my timer for 10 minutes here. And then I don't want to take away from Mr. Lenoff. And thank you. First of all, I mean, it is truly an honor to be amongst such a distinguished group, including this current panel right here. I mean, there's some real heavyweights here. My name is Chris Daniel. I am the president of the Northern California chapter of the Appraisal Institute. And I've been, by the way, Lisa Estes, who showed up as our executive director on your agenda, is not here. I've been an appraiser for 41 years. The last 26 years I've had my own firm. I'm formerly a real estate appraisal instructor in both real estate economics and real estate appraisal at Monterey College. I've former probate referee, appointed my last term by our current controller. Thank you, Ms. Cohen. And previously served as a vice chair of the Monterey County Assessment Appeals Board for about 12 years. After stepping away from that, I've testified as an expert witness in both federal and state court, and also for the county and against the county. And I've appraised hotels, motels, restaurants, lots of property, lots of real estate, all types. Moving through my presentation, with apologies to Mr. O'Neill, I did read the case on Olympia, and one of the things that really struck me that I wanted to share with specifically the Board of Equalization is in reading through that, Assessor's Handbook 502 is pretty clear, and they give very specific instructions on how to do some of these things. Specifically, they provide a method to determine the value of assembling the workforce. It's basically a replacement cost. And they specifically say here, and I'm going to read directly from it, that the deduction of a management fee from the income stream of a hotel does not recognize or remove the value attributable to the business enterprise that operates the hotel. So I certainly understand the frustration of the current panel going from board to board, and some assessors following the handbook and others not. So my first suggestion would maybe be some kind of requirement that whatever guidelines we come up with, the assessors they follow. On the other hand, I also wanted to point out that the methodologies that are being talked about now, specifically about value and intangible value, are not what I do. I'm a real estate appraiser. So when I think about real property and hotels, I think about the real estate. And before I do move on, I will point out that in defense of Rushmore, and I'm not trying to defend anybody, he does specifically talk about applying a return on and of the personal property as an example, which does not appear that the assessor did in Olympia as well. Maybe they did and I missed that. And as far as intangible values go and those kinds of things specifically, I just wanted to point out that intangible values increase and decrease. Wineries are probably a good example right now. You know, the market for wine grapes has crashed, and that industry is suffering. So the amount of intangible value in a winery right now is probably not the same as it was at the beginning of, say, COVID, or slightly before then. I'll also point out that there's probably a big difference between the Ritz-Carlton in downtown LA, their assembled workforce, which Ritz-Carlton has an extremely high level of service. So the cost and capital required to train that workforce and assemble it's probably pretty high relative to a small independent hotel that might be an owner user, or even one of the smaller economy 6 types hotels or Motel 6s. So those are going to be different, and which brings us back to each of these does need to be specific. The facts of the case matter. And obviously, as appraisers, we're going to rely on data, not, the case law is going to be guidance from the attorneys on maybe how to conduct some of these methods, but we're ultimately going to rely on data. And that's where, we have our 3 approaches, and they're simple to understand, but they are really hard to implement. And what it really comes down to, in my mind, is using those methods. And quite frankly, even our own literature tells us that, let the cost approach, for instance, for an older property is probably of little value. Well, I'm going to argue that it's of great value, especially in a case where there's some business enterprise value, or separating the real estate from the going concern. The cost approach is a direct method, and it should certainly be considered. It also needs reliable data. You need reliable replacement cost. You need a reliable estimate of land value. I also wanted to talk about, and I'm sorry, I'm rushing through here, Brianne, and I'm sorry, I can't pronounce your last name. Your idea of talking about government versus private intangibles in the real estate world, to me, that's just, if it goes with the land, it's an intangible, it's not deducted. If it doesn't go with the land, maybe it's a deduction, would be kind of a loose rule of thumb. So if say and I don't know the specifics, but let's say in the Elk Hills case or Elk Grove Hills case, if those credits went with the land, they would be part of the land, right? And remember, because whether the thing gets built or not, that entitlement is there. And when we buy, and value is always, when somebody buys property, they're buying in anticipation of future benefits. And just like that, my time is running away. So I will just wrap up a couple of ideas here for you. Let's not throw out the cost approach. It's a direct method to do that. A sales comparison approach is probably going to be a lot less applicable, especially in things like hotel valuation, because all the comparables are going to have some kind of built business enterprise value that needs to be deducted. So that's going to be a big adjustment, and we're not going to have a good source of data for that adjustment. But the income approach, another way to look at it that I don't see people talking about was, well, why not estimate the market rent for, say, this enterprise, this being the Ritz-Carlton, if we're talking about something in downtown LA, apply a cap rate, and there's a direct value method for coming up with the value of the real estate. And of course, if you were to respond to me, you would say, Chris, where are you possibly going to find that data? And there is no such data. And I would say there is data. And the best source of that data is probably the assessor's offices. The assessors put together, and through the State Board of Equalization, you already put out a cost survey. You tell us what the replacement costs are. Well, we know there's a rent comparable in San Diego. There's Torrey Pines. So we know there's going to be some sale of a leased fee hotel at some point. And if you could aggregate that data every couple of years from all the assessors, we could then have some actual data from which to use, and at least on a broad standpoint. If we know, for instance, that the cap rate for the real estate in that situation is X, or the rent is some percentage, it's 12 to 20% of gross profit or gross operating profit or gross revenue. So there are some other methods. And then, of course, as appraisers, we're always doing research, and that kind of research would be comparing lease fee sales with sales of going concerns, in which case we could presumably deduct the value of the business enterprise and isolate it. And that, to me, is probably the only direct way I can think of that you would do it. Again, simple in concept, super difficult in reality. But in today's day and world, with the data that we have at our fingertips, this stuff is becoming more and more handy. That leaves me 50 seconds for Mr. Lenoff, so I will yield.
Thank you so much, Mr. Lenhoff. If you can see us and hear us, you can go ahead and proceed, please. Just about 10 minutes.
Okay, thank you very much. Actually, I'm on East Coast time, so we're coming up on my bedtime anyway. Thanks for inviting me to participate. Uh, uh, I was told, Mr. Emron said, I asked him, what do you want me to talk about? And he said, listen, make notes and respond. So I've got 3 points and 1 recommendation. Quickly on my background, I've been appraising for more than 50 years. That's 50. And I have written courses, articles, and books dealing specifically with this topic. 2 books that are used in the course that deals with this topic in the Appraisal Institute. I was the lead developer on the course in the Appraisal Institute. There's only one that deals with this issue. And the articles, many of them deal exclusively with this issue. And I publish those mostly in the Appraisal Institute Journal, but also in the Assessor's Journal, and also in Property and Probate and Real Estate Lawyer. So I have a good background in this, and I do teach the courses in the Institute, the one that deals with this topic in particular. So the issues, the first issue I'm going to just quickly touch on is this concern about the intangibles as they enhance the real estate. I think all that's going on there is that you need to understand when you come into an appraisal problem like this, you need to have what's the value premise. There are 2. One is value the real estate as it contributes to the total assets, the going concern, or 2, value the real estate in liquidation. And our course deals with the former, valuing it as it contributes to the total assets. Example, you've got a couple of NASCAR racetracks in California. I've valued a bunch of NASCAR tracks, and I can tell you that absent the NASCAR affiliation, the track is worthless. I mean, worthless. And so if you go in to do a tax assignment on the racetrack that's affiliated with NASCAR, and you realize that that affiliation is intangible, you use the going concern premise, which says value the track as a part of the racetrack going concern, and then get the intangibles out of the equation. In other words, don't value it as dirt, as a liquidation. And I think that's all that was involved with that issue of the intangibles enhancing the real estate. The second item I want to mention is this concept about remove the value of the intangibles. That's true, but you have to understand value is a combination of a return on and return of an asset. For example, think of a bank. A bank is like a hotel owner, and I will tie that together in the last example, but they lend you $1 million and they gonna expect to get the $1 million back and get interest on the $1 million. So the $1 million back is the return of, and the interest is the return on. So that is the immutable law of business, return on investment. And what you have to understand when you value the intangibles, you have to capture both elements. You can't just value the return of. No bank would make a loan to you. Here, I'll give you $1 million. Just give it back to me in 3 years and we'll be good, because they wouldn't be in business. They're in business to make money, as are hotels. And so that gets me to the second point, which is the management fee method. I only bring it up because it was brought up by the representatives for the assessors. And I will just say very quickly, I have testified in numerous cases in California. Do you hear me okay? Okay. In California, both at the appeal board and at the Superior Court level, and on this topic. And this issue it gets, once you explain the management fee method, it becomes illogical. And I'll tell you why. If you accept a management fee, as Chris said, the Rushmore method includes more than a management fee, but the assessor usually just uses the management fee component. If you're doing that, you say, okay, I'm a property owner, just like a bank. I'm gonna hire Marriott to manage my hotel, put their flag up and everything. And the value of that is what I pay Marriott. So I get nothing. What if everything related to the intangible is what you give Marriott? You'd never do it. You get nothing. It's like the bank who makes the loan and doesn't get any interest. So it just makes no sense. You cannot do that. And I think actually to suggest that the Rushmore method is simply the management fee method is a mischaracterization if you read some of his appraisals on how he employs it, not how he talks about it. Okay, the last thing is I would like to recommend that if you really look, there's a competency rule in the USPAP. All appraisals, I'm an MAI, I've had 6 of the 7 appraisal institute designations and a CRE. So I'm qualified to do supposedly any type of appraisal, but I'm not allowed to do any type of an appraisal under USPAP because I have to be competent to do them. And I might not know anything about a nuclear power plant or even a NASCAR racetrack. Therefore, I wouldn't be able to do it under most circumstances. I think that's the problem with the assessment office. They're general practitioners being asked to do very sophisticated pieces of assessment valuation. And what I would recommend is the assessment offices carve out, look, you're going to learn how to do this. This is what you're going to do. Hotels or properties with intangibles or whatever. And that involves getting education. Most of the assessors never take the education specific to this particular topic. And absent the education, coupled with a lack of experience, means you're not going to be able to answer the question, and then you really shouldn't be trying to answer the question. So for me, that's all I think I have time to discuss. But as I say, I'm at Easter time, so it's okay with me. Works out fine.
Thank you, Mr. Lenoff. That was excellent.
Wonderful. Thank you so much. Really appreciate the whole lineup here. Let's go ahead and open up for questions from the board members. Or do our board members have any questions for this panel specifically? I'll go ahead and get started on this then. I want to talk about what the updated guidance should look like in the future. Handbook 502, Chapter 6 currently lists 7 enterprise intangibles: goodwill, customer base, going concern value, workforce, contracts, licenses, and the right to do business. This was a list compiled over 30 years ago. Based on what the courts have addressed since then and on your experience and your practice, what is a complete, accurately framed, and usefully organized list look like? What would you add, remove, or restructure?
So there's actually a chart in that chapter which contains even more than that, like it has for memberships of fraternal societies. If you wanted a complete list, I could give you a list that covered 2 full pages in a text written by Robert Riley and Robert Schweiss. Because intangibles appraisers like Ms. O'Connor have enormous lists. I think what was provided in AH 502 was, here's examples. If you really want such a list, it's going to have to appear, say, in a guidance document which I think is the way to go here, that the board should issue a guidance document like it has, in all these other topics. And it could include such a list. I will say this, certain things like stock exchange seats, for example, probably we don't need that one on the list. So the list should probably be culled down to what is most common or typically seen. You're not going to find in the list, for example, a transient occupancy tax agreement used for purposes of rebated tax for purposes of developing a hotel at a convention center. That is so specialized, that's not going to be on any list. So,
And I would add, you just don't want to limit it to that list because other intangibles could come up, but I think you could give a broad, like Mr. O'Neill indicated, a broad stroke of what's common and what will get us through about 90%, 95% of what.
Yeah, absolutely.
and just real quickly,
Please.
In the draft proposed LTA, I gave you also the 6 factors that Ms. O'Connor uses, which are typically found in ASA Business Enterprise Appraisers texts. And those are general factors that could be applied to any intangible.
It goes kind of segues into my next question about property types. The handbook currently addresses intangibles as a general matter without distinguishing property types. But the enterprise property analysis looks fundamentally different from a hotel operating under a management agreement, a utility operating under government regulated rates, a franchise restaurant, or even a development project built with government incentives. Should updated guidance include property type specific sections? And if so, which property types are most urgently needed in their own framework?
So I'll quickly start, and then I think maybe Ms. Rabowski will also have something to add. These are what we call complex properties. Complex properties are anything from a refinery to a shopping center to a hospital to a hotel to a theme park. We could probably come up with a list of 15 of the most commonly found or typical complex properties. That, but even so, I think what's more important than saying putting them in property type categories is putting them in intangible type categories. Because an assembled workforce in a refinery looks a lot like an assembled workforce in a hospital. You know, it's a matter of how many employees, what's their salary, what are their benefits, how long does it take to train them? And those are the factors that change. So I think more beneficial would be, instead of, we can create a list of complex properties that's actually in the proposed LTA, but I think what's more important is creating a list of, and then grouping them, of the intangibles that are typically found, and putting them by method of valuation, the template that Ms. O'Connor had talked about.
If I could just add one other, two quick things. Don't view the valuation of intangibles as something that just floats in space separate from the real estate appraisal process. I am at my best when I am teamed with a real estate appraiser who gets this, who understands how to do market parameters for the pro forma. My work then flows from that, and there's some conclusions that can be made about the real estate. That's what makes it, I think, complex, as you're stating. And one other thing is that up to now, we have not really focused, I think, we haven't added to our focus the financial assets, the net working capital, current assets minus current liabilities. The reason why it's important in property tax context is we have to value the unit in place, not as if they're getting their working capital from a parent company. It has to be embedded in the valuation of the inside. So it is, again, you got to tailor this to property tax. So I would, as you're making notes, if you could put in there, we need to deal with net working capital in future templates, I think.
Working capital, by the way, is in Rule 8E. It says to address it there.
Thank you. Any other members want to speak to that? But any Q&A from our members? Mr. Vasquez.
Well, thank you for your presentation, Mr. O'Neill. I just was looking at your document that you dropped on us. I haven't a chance to really go through it, but it looks like it's something that we really should take a serious look and see what we can do to incorporate it. And I'm curious to hear from, I guess, some of the other stakeholders that are here today, that I'm assuming they also got a copy of it, and see what input they might have on this moving forward. But this, I guess, for any one of the panelists here, given your research and experience, not only here in California, but in some of you I mentioned in other states, what, if anything, is going on in some of the other states that maybe we should be looking at that could help us as we move forward with possible LTAs on this issue? And I open it up to all.
The issue of hotels remains very active. There are some very good cases that have come out of the Minnesota Tax Court on hotels. There's a very good case that Mr. Lenhoff actually testified in, a decision that came out. I don't remember the name of the hotel. He probably does. It came out within the past year. There are good appellate court cases coming out of Florida on the Disney World hotels, which are published appellate court decisions coming out of the Florida appellate courts. Those are the two states that I see are active. Um, You may know a few other states, Ms. Connor.
The Florida, for example, and they are evolving into a Florida method that's sort of interesting, where our principle here is identify, value, and exclude, and you're appraising the intangible and deducting it from the going concern. They strip out what they consider intangible revenue, like food and beverage revenue minus the direct expenses. It's a variation on the California theme. But all states are grappling with this.
I do think it's important to raise, however, that we are subject to a very specific set of laws and statutes that are specific to California.
Yes.
And as Ms. O'Connor said, we are leading the way in this field. So I would hate to accidentally borrow from another state in a case that has nuances in the law that are incongruous without recognizing it. And so I think generally speaking, the California courts don't give a lot of credence to what other states are doing because of those differences and that feeling that we are the leading state. So I would just caution a little bit around sort of that inquiry.
I appreciate it.
Thank you so much. Right on time. So, Mr. De Pasquale, do you have it? You and your team have some closing statements here, maybe 90 seconds?
Thank you. I just want to say, let's not forget about the front end process. The assessor needs to know when there's an intangible issue, and that needs to be updated on every form that they utilize or that they review. That really begins this process. What follows is now what legal and the valuation appraisal community will adopt, but without giving that lead on the front end, we're not going to solve the problem. We'll still have backlog appeals, and we'll have workload challenges because we will not have identified things soon enough, and it'll just start to stack up again. So I encourage the board to really look at updating the transaction forms that accompany transfers, look at the personal property submissions, look at any other 441D, things that the taxpayer is asked to provide. There should be a section on intangibles. Where it goes from there, that's then up to the assessor and this process. But without that, we're going to be no further along because we will still be playing catch up because the assessor will never know which transaction. I think it was mentioned earlier, we see a transfer, we don't know what we're looking at half the time. So we need to get better at the front end reporting, compliance, and the taxpayer has to do their part if this is an issue that they want addressed, and for the assessor to do a proper job on the return side. That's all I'll say.
Wonderful. I want to thank everyone so much. A lot of great experience at this table, and it was really insightful and eye-opening on your testimony as well. So let's move forward now to public comment. Are there any members of the public that would like to comment that are here in person on agenda item number 4? Seeing none, let's go to the AT&T line. Mr. Operator, are there any members of the public that are on the phone line that would like to comment on agenda item number 4?
Please press 1 followed by 0 if you'd like to make a comment. 1 followed by 0. And we have no one in queue.
Thank you, Mr. Operator. So we're going to go ahead. Madam Secretary, if you can call the next item.
Our final item is item 5, wrap up and next steps. Summary of the testimony and discussion received during the meeting, confirmation of the next opportunity to meet, and general closing remarks from the Deputy Controller and board members.
Thank you so much, Madam Secretary. I'm going to look to my board members. Any closing remarks? Let's go ahead and let's start with Mr. Vasquez, and we'll come on down.
Thank you, Deputy Controller, for putting this thing together. And I wanted to thank especially the different stakeholders that showed up today and the assessors. I know that we had a few assessors show up today who made the time to show up in person. Really appreciate that. I think there was some real good information, at least for me, in terms of things that I didn't really think about. And I always wondered about what's going on in some of the other states, and I think Ms. Robuski hit it on the nail when she says, just to be cautious with, obviously California's got different rules and legislation and laws that could impact trying to adopt something, for example, from Florida as an example. But I really appreciate the fact that you folks came together and at least shared your thoughts and ideas. Looking forward to the follow-up, and I'm hoping that you all stay engaged, not only the panelists that, the two panelists we had, but many of the assessors, and I know Joaquin Torres is going to definitely make sure that the assessors throughout the 58 counties are involved. So looking forward for that follow-up and continue to work on this. Hopefully see if we can't come up with something that brings some consistency, at least throughout the state of California, even if it's maybe one or two items that we can deal with. And I know in looking at it briefly, what Mr. O'Neill presented in terms of an LTA might be a good beginning or a good start for a possible LTA. Thank you.
Wonderful. Thank you so much. It's a good reminder. Please submit anything that you weren't able to orally present in writing. We are going to take a deep look at it. Chair Lieber.
Thank you, Mr. Emron. I really appreciate the work of the controller and the controller's office in putting this hearing today and together for us, and everyone who has traveled or been engaged with the board over the past year or so on this. And Mr. Emron, as you prepare the report of this work group meeting, I hope that you can attach all the written communications that we've received to it. And I know that all of us on the board are going to continue to go through those communications and be in touch for clarifications. So I want to really encourage everyone to submit those written comments as well, so that can be part of what we're discussing going forward. Thank you.
Thank you, Madam Chair. So definitely a Herculean task, but we finished day one here, and I really do feel good about it. I feel like conversations and the type of dialogue that we're having is a real core part of democracy and kind of finding consensus here. So on behalf of Controller Cohen, I want to thank you all for joining us today. For those that traveled far and wide, the Controller's Office will work together to circulate detailed minutes of today's session to all participants. I'll go ahead and work with the chair to confirm upcoming dates on the work group meetings, and I'll share that with the participants. In the meantime, the Controller will ask everyone to please submit written comments, identify specific issues, specific handbook passages, and specific methodological questions you believe we must address. The more specific your input, the more useful our next agenda will be. The work group's final recommendations meeting will be scheduled in due course. So between today and then, let's continue these discussions and dialogue. Your expertise and guidance is very meaningful in improving California's assessment of intangible assets in a fundamental way. This is what we owe to our counties, our taxpayers, and the integrity of California's property tax system. So let's continue that work, and I'm looking forward to the discussions ahead. And we are gonna adjourn now here at 3:11 p.m. Until next time, thank you, everyone.